The next battle in the Disney versus DeSantis legal saga is afoot. And at the heart of it is this man, which is Judge Mark Walker. And Florida has already taken action on this, but I'm going to tell you today in this episode, in this video, why this is possibly the biggest battle for Disney and why Disney is really win or lose on this particular motion that they are trying to fight today. So we're going to break it down for you and explain all the Florida law and why this is such a critical battle for Disney that they cannot afford to lose, but probably will. Of course, I am your host, Andrew Esquire, and this is a legal mindset. We teach you to be your own judge. And today we're going to get into it with Florida law. And this really is a huge aspect of this entire battle between DeSantis and Disney. And consistently, what we are seeing is that Disney and their attorneys seem to be relying way too heavily on federal law, out of state law, rather than looking at what is going down in the state. And the battle over Mark Walker is exactly where we see this play out. So, what's going on? Let me give you a little recap for those that have not been following this today, or really at all. Judge Walker is the judge that was assigned Disney's federal case. Now, remember, there are two cases now pending for Disney. One case in federal court where Disney is alleging 5 specific constitutional violations. And there's the state case, which is dealing with the proper law under Florida law in Orlando in the Ninth Judicial Circuit, and that is involving the illegal and unenforceable contracts and restrictive covenants that were entered into by Disney at the last second with improper notice, no consideration, and a bunch of other fundamental flaws, and that is pending in state court. So you have the district suing Disney in state court. That is still pending. That was filed after the federal case. Then you have the federal case, and that is the constitutional claims. Now, of course, the federal case is all that the mainstream media is talking about. And in fact, the mainstream media seems to, at large, be focusing only on the First Amendment claim. That is, this claim that Disney is somehow being retaliated against or silenced by Ron DeSantis through their passing of a bill which sunsetted multiple older districts, including but not limited to Reedy Creek. So because of that, all of these charges, or rather complaint causes of actions, the contracts clause, the takings clause, due process clause, and 2 First Amendment violations. They're really only focusing on the First Amendment violations, and frankly, really only the last one, really only the 5th cause of action, is really what everybody is talking about in the media. But based on the framing of this complaint, as we've talked about, the First Amendment is actually one of the weakest arguments they have. Out of all of these arguments. In fact, the very structure of this is such that they lead with what they believe is their strongest argument, which they believe is the Contracts Clause argument, and end with their weakest argument, which they believe is the First Amendment violation. But yet the mainstream media has run with this just the same as the mainstream media has been running with reporting inaccurately on the name of the Parental Rights and Education Bill. Once again, the mainstream media and the Disney shills using the Don't Say Gay name, which is about as accurate as the anti-grooming name, both of which are not the name of the Parental Rights and Education Act. That being said, they're really hedging on this First Amendment violation claim. And one reason why this is so important, why focusing on these claims is so important, and why getting Judge Walker is so important, is because what they really need is this. They need a judge that is going to keep this case going even while the state case is going on in the state court. So why is that a problem? Well, listen, what happens typically is that when there is a conflict between a state and federal case, when the federal case depends largely on what's going on in the state case, they defer to the state. Between the federal courts and the state courts, there is an automatic deferral, right, an abstention to the state courts. They allow the state courts to rule on state law because that's what state courts are there to do. So the state case really deals with those restrictive covenants and those that developer agreement, and those pertain to the first 4 causes of action. To the cause of action for the contracts clause, taking clause, due process, fourth cause of action regarding the first of two First Amendment claims. So 1 through 4 are really completely wiped out while the state case is going on. However, there is a possibility that if your judge was extraordinarily favorable, one might even say biased, they might be willing to keep the case going based on that fifth cause of action at the federal level. They might be willing to say, okay, we're going to, throw out or hold off on cause of action number 1 through 4, but we're going to stay on number 5 because that's the only one that doesn't hinge on the developer agreement or on the restrictive covenants. We'll go on number 5, which is, by the way, their weakest argument. And let's say you had a biased judge who was willing to rule in your favor. Well, in that case, you might be willing to prevail on that fifth cause of action, while in the state court, the district is very, very likely to prevail. So then you'd have some sort of conflict. You've had confusion. This would have to go up to the appellate court, possibly even all the way up to the Supreme Court of the United States, where I'm sure the right resolution would be had. However, that would be delay. That plays in Disney's favor, particularly as, well, DeSantis is wrapped up in campaigning, so he's not able to pay as much attention on this. And also, the longer they can drag this out, the more they can hold it over DeSantis' head on the campaign trail. Even though at heart of it, Ron DeSantis really has nothing to do with this. This is really between the special district, rather than new special district, and Disney. Ron DeSantis, frankly, shouldn't even be a party to the federal lawsuit. That being said, that is their strategy. So understanding Disney's strategy is key to understanding why they need, not want, but why they need Judge Walker, why he's so critical, why Judge Walker here is so critical to their plans. So what are their plans and what do they plan on doing? So let's look over here. So obviously we had the motion to disqualify. Now, this motion to disqualify was filed by Ron DeSantis' team. And this was to disqualify the judge for sua sponte, which means out of nowhere, offering Disney as an example of state retaliation in two separate cases. That is Link versus Corcoran, where he made a comment about, is there anything in the record that says we're now going to take away Disney's special status because they're woke? He said that out of nowhere. And then in a second case, which is Falls versus DeSantis, he went out of nowhere and says, and then Disney is going to lose its status because arguably they made a statement that ran afoul of state policy of the controlling party. So two statements clearly referencing Disney. These are in previous cases where he was not involving Disney, that did not involve Disney at all, but he offered it up as an example of what is impermissible. And that's the problem. He seems like he has already come up and made a decision on this as to how he would rule in Disney's favor. He seems to believe this is retaliation before they've even tried the case. He comes into it with a certain bias. Now, Disney has opposed this motion. They've now filed a motion in opposition to oppose the disqualification of Mark Walker. They want Mark Walker. Like I said, Mark Walker is their best chance for victory. And guys, a lot of you in the comments want me to make the best arguments for Disney, and I'm trying to do that. I'm trying to say, look, and be completely honest. Having a biased judge is probably the best case scenario for Disney to win. That's just being realistic. Then this is the legal mindset. We're just talking realistic facts here and what actually would get the job done. And what would get the win done for Disney would be a biased judge. That would work out deeply in their favor. So they want to fight as hard as possible to keep Mark Walker. So what they said in their motion is they said that the court rules do not prescribe a hair-trigger disqualification standard that defendants suggest. They said that the rule sets a high bar, right? A high bar to prevent parties from trying to effectively veto judges whose decisions they do not like and shop for a judge more to their liking. And then they go on to say disqualification is allowed only if prior comments expose an incapacity on the judge's part to consider a new case on its own merits. The comments here come nowhere close to that standard. Well, this is one of those situations where I believe there's a problem with Disney's lawyers. I think Disney's lawyers, they may be fantastic lawyers outside of Florida. They may be great lawyers in DC, New York, and California where they're barred. However, they don't know a lot about Florida law. And frankly, they're really at a disadvantage because in terms of Florida law, they're going up against the counsel for the district and DeSantis. which is right now Alan Lawson, Judge Alan Lawson, former justice of the Supreme Court of Florida. So this is the person, Judge Lawson, former Judge Lawson, now just Mr. Lawson, or Mr. Lawson Esquire, if you will, who is representing the district in their side, and that is opposed to Disney. So Disney has against them someone who not just knows Florida law, he ruled on it. So they have someone who is absolutely 100% entirely competent in Florida law. And if the Disney lawyers studied Florida law, they would understand the rule for disqualification of trial judges under Rule 2.160. Now, this is a very straightforward rule of procedure, and it states the situation in which what you must plea and how judges are disqualified. And all it says is, look, the motion has to be in writing, and it has to allege specifically the facts upon which the movement relies as the grounds of disqualification, and be sworn by the party signing the motion under oath or separate affidavit. So essentially, it's just got to be in writing, state facts and reasons, and then be signed. That's it. And the grounds are that the party fears that he or she will not receive a fair trial or hearing because of the bias or prejudice of the judge. Now, this is Florida law, and this is why they don't understand it. But in Florida, as pointed out by my good friend and friend of the show, Stephen Gosney, a very experienced Florida attorney, someone who's been in Florida courts forever, the first motion to disqualify is a gimme. And this is a difference perhaps in Florida than other states, is that the initial motion is treated different than successive motions. So the first motion to disqualify a judge is pretty much presumptively granted. And you see that in the lettering of the actual rule of procedure. So let's read that together, and I'll explain what that means in plain English. So, determination. The judge against whom an initial motion to disqualify under subdivision D1 is directed shall determine only the legal sufficiency of the motion. So let me pause there. The legal sufficiency means, does it meet those basic criteria I just read off? Is it in writing? Okay, everything's going to be in writing, right? I mean, you're not doing this orally. Number two, does it state facts and reasons? And three, is it sworn under oath? This motion has all of those things. And it says further, and the judge shall not pass on the truth of the facts alleged. What that means is, in plain English, is they have to accept everything in the motion is true. They do not have an option in Florida to look outside the four corners of the complaint. We often say looking at contracts, the four corners of the contracts, but it's the same here. You've got to look at this very tightly. You can't look outside of it. You can't look at your feelings. No Yoda, search your feelings. You know this to be true. None of that, or what's that, Darth Vader? Not really sure though. I think it was Darth Vader. But if the motion is legally sufficient, the judge shall immediately enter an order granting disqualification and proceed no further in the action. So as long as it meets those basic legal requirements in Florida, the judge is gone. They have to remove themselves. If any motion is legally insufficient in order denying the motion shall be entered immediately. No other reason for denial shall be stated, and an order of denial shall not take issue with the motion. So there is no other reason other than it was not in writing, had facts, and was sworn. If it meets those three things, boom, you're done. You get it. Now, successively, for the second or third motion, so let's say this went to another, crazy, super biased judge, well, that's going to be harder to disqualify. That standard is the judge has to rule that he or she is in fact not fair or impartial on the case. So the judge has to say, I am not impartial. So the judge pretty much has to rule on themselves. At that point, the judge would probably recuse themselves if they really felt like they were impartial or biased or whatever else. So this is the difference, and this is the big deal with knowing state law versus knowing federal law or knowing other states' law. And this is why I think Disney is bound to lose this. We can say goodbye to Judge Mark Walker. I think presumptively he is out the door, and we are in fact going to see another judge on this case. Now, if you guys are enjoying this type of coverage, these type of easy explanations in plain English where I break down not just the substantive law, but also the procedure and give you guys updates, make sure you smash the like button and let me know you're enjoying these case updates. This may be minor, but listen, guys, these motions, they can dictate whether the entire case is won or lost. The trial is being fought before we actually have any sort of ruling, whether it's summary judgment, whether it's a final judgment. It's being fought in the motions, and these are massive. So I do plan on giving you the most up-to-date news from both the state and the federal cases. Guys, make sure you like, comment, subscribe, and I will catch you later. As always, peace.